the trial captivating a nation.
Read is accused of killing her boyfriend, Boston police officer John O'Keefe. The defense claims she was framed in a police cover-up.
On the scene to keep you informed at every turn.
In Dedham, Katie Benoit, NBC 10 News.
With live updates and legal analysis.
What happens then? Does the trial have to stop?
A lawyer's only as good as his or her word.
They failed miserably and they'll continue to fail.
On air, online, and on the app. NBC 10 News has the latest on the retrial of Karen Read.
Hi, everybody. The latest is that the jury has gone home for the day. They come back tomorrow. Now, there was a flurry of excitement today when some questions came in from the jury for the judge. She couldn't answer all of them, but it did lead to speculation as the day went on that maybe we're close, maybe the verdict today. In the end, turned out that wasn't the case. The jury came in. They'll come back tomorrow. All right, this is Karen Read's dad outside court saying he prays a lot. That was basically what he told us today. He's a religious man. He prays a lot. Go ahead and play that.
Get the medical testimony from Dr. Scotty Bello, prosecution's own and the state's medical examiner, could not say John O'Keefe was hit by a car, not consistent with it. And the manner of death, undetermined. And then you go to Dr. Elizabeth Laposada, former chief medical examiner for the state of Rhode Island, now professor at Brown University. What do you see there? The same thing. The body injuries are not consistent with the vehicle strike. You know, it's so much. It should raise everybody's eyebrows that we're here doing this.
He actually spoke to reporters twice today, and that was a reference he was making to the medical examiners. He's right. There was no conclusive evidence that John O'Keefe was hit by a car, although the state suggests he was. All right, let's bring NBC 10's Katie Benoit. Katie, let's go over the first of a series of questions that came in today, and then Peter Elikann, our legal analyst, you can tell us whether they're significant or not. Go ahead, Katie.
Sure. So there were a bunch of questions, 4 questions from the jury today. And one of those questions was asking, what if we're deadlocked on the third charge? What if we all agree not guilty on 2 charges, but then what happens if the third charge we can't agree on, which was a big thing because of the mistrial, which happened last year. So when that question came up, naturally, you know, it was kind of a reminder of what happened last year with jurors coming forward after the trial. And there were a couple of other questions too about
Katie, you know what? Hold on. Let's do one at a time. So Peter, you come in with regard, Peter, to the question of, well, we not guilty on 2. I guess we're all thinking those are the worst 2 for Karen, the top 2. Does that mean we have to make a decision on one of the third or lesser charges? Because you pick up the analysis here, and then we'll go back to you, Katie.
Yeah, you know, I've long ago given up trying to get into the heads of jurors. I've been wrong so many times. It's like reading tea leaves. It's voodoo science. And yet that was the indication that we all came out with, that they say if the deadlock, I mean, they think not guilty on 2 of the counts and deadlocked on 1. And if that's true, it's like shades of the previous trial that are we ever going to get 12 jurors who are going to, you know, unanimously think she's guilty? Are we going to deadlock again? And then the prosecutor has the option to have a third trial and keep doing it. There's no legal limit to it. But that was sort of the guesswork that people are thinking, that maybe when they said to it, what if we have not guilty on 2 and deadlocked on 1, that's what they were experiencing. Possibly, or we all could be wrong. They could all, or if they're deadlocked on 1, they can all agree to it by tomorrow. It's just anybody who's trying to guess when they're going to, come to a final decision or not is it's just pure speculation. We never know what a jury's going to do. But if they are going to be deadlocked, that would mean that this case could go on for a few more days, like the last one. Last one did. Otherwise, those first questions, they asked some questions earlier that it led people to believe maybe they were really, really close at that time. And then that fourth question, when they asked, what if we're deadlocked? At that point, we all took a breath and kind of backed up and said, wait a second, maybe we could be in for the long haul.
Well, Karen Read's got to be feeling pretty good, I guess, with the news that, well, we're not guilty on 2. And if she's assuming, like the rest of us, that's the most serious, they might be debating whether or not it's a simple operating under the influence. All right, Katie, continue now with the specificity of the questions. the second and third question. Go ahead.
So the OUI charge was another question that came up. On the verdict slip, it's a little bit confusing because there's the manslaughter charge and then lesser included charges. And one of those is a simple OUI charge. And today the jury came back and asked, so when was that window? The alleged drunk driving, did it happen at the party, at the Canton House party, or did it happen when Reed went to go find Joe Key? So that was one of the questions. And then also one of the questions was about if they convicted her on the OUI charge. They didn't say that specifically, but they used that as the example. So it sounds like maybe that's what they were thinking. What would happen with the rest of the verdict, the rest of the lesser included? It's kind of confusing. So that resulted in the verdict slip being updated to give some clarification, which the defense has wanted all along.
Yeah. Peter, just hold off on the updating of the verdict form. How would you find somebody guilty of operating under the influence if nobody was there? Even though she admits she was drinking, but there's no breathalyzer, there's no field sobriety test, there's nothing. How would a jury come to that conclusion?
That is going to be a tough one because you're right, because nobody was there. You don't need a breathalyzer. Often when the police arrive on the scene, somebody refuses a breathalyzer, but then the police write a report and they say, oh, slurred speech, unsteady on feet, can't pass the field sobriety test, alcohol on breath, and you can convict somebody based on that. But if the police aren't there and you have her saying that she was that she did have a number of drinks, and then you can hear her voice sounding a little kind of as people say, a little crazy or something, when perhaps because she was so distraught or with grief or wondering where he was, and so she was getting very fraught. That's going to be tough to prove in a drunk driving charge. If she is convicted of that, I mean, normally in Massachusetts, I've been doing this for years and years. I have never seen anybody who has no prior criminal record have a drunk driving charge and go to jail. Technically, on the books, you can go to jail for a couple of years in the House of Correction, but that isn't what normally happens. As a matter of fact, here in Massachusetts, we have something called continuance without a finding, where usually on a first offense drunk driving charge, the judge will say something like, okay, if you don't deny, you admit you did it, we won't find you guilty. We'll let a year go by, stay out of trouble, take our alcohol education course. We're going to suspend your license for 45 days, and then ultimately it'll be dismissed. So if she was ever convicted of that misdemeanor, that would be considered a victory for the defense.
You know what? This sounds almost absurd. I mean, what if somebody said, I was out drinking with a buddy last night. He was drunk as a skunk. And go look at the tape. He was drinking and he drove home. I mean, it seems absurd without a field sobriety test, without police involvement.
I agree with you. And I don't know that I've ever heard anybody convicted of drunk driving just on somebody saying, I was drinking. And some people can say, well, she looked drunk to me, but that wouldn't, and that'd be hearsay. That couldn't be used. I don't know how they can do that. A jury could come to that conclusion and it's a compromise vote. Well, we want to nail her on something, so we'll get her on the most minor thing. But I don't know how really legally you can do that. As I said, you don't need a breathalyzer, although a breathalyzer will really help nail you on it. And it's you can beat it a little easier if you don't have a breathalyzer. But other than that, I've always seen it where the police are on the scene and they have a field sobriety test and they make their observations, and they'll also mention about your driving. We could see you were weaving in and out of lanes and you crashed into something. I don't see that here at all. So I agree with you on that, Gene.
The prosecutors can charge it whatever they want. You could put something out there and then take a shot. You'll get it. Let's get her on something at least. Maybe that's the thinking here. All right. Katie, let's play Judge Cannoni now, reading the first three questions, and then I'm going to ask you about the back and forth between Cannoni and Alan Jackson a little later on. But let's play Judge Cannoni reciting the first three questions. Go ahead.
For the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m. The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
Well, you could see the first question about OUI was we to consider whether she's driving drunk when she left the house or when she came back later. It's a well, that's a murky area. All right. Later in time, the fourth question came in. Judge Cannoni and Alan Jackson were arguing a little bit back and forth about the nature of the fourth question. Play that, and then we'll get Katie in on this. And Peter, you can also comment on this. Go ahead.
So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Okay, come on back to us. All right. That's what she did. She responded with regard to the question about we're not guilty on 2. If we can't come to a decision on the third lesser charge, is that deadlock? And she responded, that's a theoretical question I can't answer right now. All right, Katie, is that your synopsis of it too?
Yes, and the defense is concerned about this because remember the mistrial that happened last time, and then eventually jurors came forward saying they were supposedly deadlocked on that manslaughter charge and had agreed to acquit Reed on the other 2 charges. So the defense is probably thinking, oh no, here we go again, and trying to, let the jury answer their questions and concerns. But the judge says that it wasn't appropriate at this point.
All right. Well, Peter, given that the defense made a pretty strong argument that the verdict form should have been altered to make it absolutely infallible, easy, explainable, do you think they had a point here in doing that, given what happened today?
Yeah, their worst fears are being recognized. Now, I will say that this jury slip is used frequently. It's been tested through time. And so Judge Cannoni is not on, shaky legal ground saying, no, I just want to go with the same old. And she's allowed to do that. I don't think anybody's going to, win an appeal on that. However, I don't see what would have been wrong with trying to clarify. I mean, it wasn't done last time for the first trial, and the jury was genuinely confused. And now here a second time, they were also raising questions about it and were confused a second time. So even though you can say, look, all the judges use this slip, it's still, I don't know why the attitude has to be that, well, this is how we always do it. You can improve on that. And I hope it may not be up to Judge Cannoni, but I hope that in the future they come up with better jury slips and maybe test it with the Supreme Judicial Court or something like that, because I don't see what's wrong with trying to make things clearer and more concise so people can, it's really understandable.
Okay, well, I agree with you on that, and let's all leave on agreeing today. And are we in agreement that it looks like tomorrow's verdict day, Katie?
It's unclear. You kind of never know. It maybe seems like at one point today, those first couple questions, the verdict could be coming, and then at the end of the day, there was no verdict. So it's hard to know what these 12 jurors are thinking. Could be tomorrow. There's no court Thursday because of the holiday, so it could be tomorrow, could not be. So we'll just have to wait and see. But We'll be inside the courtroom waiting.
Peter, no court Thursday. Tomorrow seems like
well, it all depends on something, and that is, are they deadlocked? If they are, like the last one, they're out 4 or 5 days, and what happens if you report to the judge you're deadlocked? The judge always is going to say they don't want that, weeks and weeks of trial to go to waste. So the judge is always going to say, well, go back and try again, and they go back and try again several times, and then they give kind of what's called a explosive lightning charge where they really push them. And then at some point, if they keep coming back, say, we just can't, at some point, you got to throw in the towel and give it up and say, this was a mistrial.
All right, Peter Elikann, thanks. NBC 10's Katie Benoit. That concludes our briefing, folks. Thanks for joining us. We'll do this every day until we get a verdict. For now, I'm Gene Valicenti. Have a good rest of your day.
The trial captivating a nation.
Jennifer McCabe spent longer than anticipated on the stand, sharing what she says Karen Reed said as first responders were trying to save John O'Keefe.
Your client said, I hit him, I hit him, I hit him.
She repeated,
I hit him. I hit him.
She's testifying to whether or not it was a direct statement, I hit him, versus a question, did I hit him?
It's always inconsistent. Don't take anyone's word for it.
And no more nonsense. Let's just try this case.
NBC 10 News has the latest on the retrial of Karen Read.